Afternoon. So we should get started. I want to welcome those out in the West. Good morning to you, and those out in the East. Good afternoon. Welcome to Boost's Child, Youth, and Advocacy Center's webinar series. My name is Rachel Birnbaum, and I'm going to be hosting the webinar today. I'm a professor at King's College at Western in London. I teach both social work and in one program, and children and the law and legal issues in the childhood studies program. Before we begin our session, just a few housekeeping points. For those participants that are listening in French, please click on where it says floor at the bottom left of the screen and then select French, and you will hear this in French. Also, for those that are in English, leave it on, click the present French. Also, for those that are in English, leave it on, click the presentation screen for English. You can also download the presentation in French by clicking on the documents on the right as well. There will be a question and answer during the last 5 or 10 minutes of this webinar, so please do wait or submit your questions on the left-hand panel where on the toolbar on the right by clicking messaging and then participants, and please type in your question. I will certainly get to them once I've completed. If you're watching this webinar in a group, please enter the number of participants in the group by clicking on messaging and then participants. So let's get started. This is sort of a two-part presentation that I'm going to do on the July of this year. So the learning goals for this afternoon are to learn about the importance of children's participation during separation and divorce, learn more about the views of the Child Report. Out west in British Columbia and Alberta, sometimes they're called Hear the Child Reports, Voice of the Child Reports. In addition, in Nova Scotia, they're also called Views of the Child Reports. And I was responsible for at least doing the research and getting it going here in Ontario, and I'll talk about that. But also how it fits very well into the centerpiece of the new Divorce Act, as I said, that's coming into play in July of 2020. So when I'm talking about hearing from children, there are many different ways, both inside, both before the court and also from children. There are many different ways, both inside, both before the court and also outside of the court, that children can be heard. So oftentimes there are statements made from parents that are written in affidavits. And the question becomes, how reliable are they? Because sometimes parents hear what they want to hear. As you know, we live in the age of technology where everyone's walking around with a cell phone and everybody wants to take a picture and record their child. So there's also that way of getting that kind of information before the court. It's also an issue about how reliable is it? Are these recordings done without the permission or knowledge of the child or of the other parent as well? And then there's hearsay statements from teachers, doctors, therapists. I'm sure you have been perhaps asked as part of Boost when you're dealing with young people to perhaps write a report or report on something. Across the country, there are custody and access assessments or parenting assessments. Every province and territory has some version of private as well as government-funded reports that are provided to the court, both, as I said, within the court, if the matter's before the court, or if the matter's in mediation, or if it's in some kind of mediation arbitration. There's the Views of the Child Report. As I said, out west, it's Hear the Child, Voice of the Child. Out east in Nova Scotia, as well as Ontario. And then there's a lawyer who's representing the child, telling the court about what the child's views are. Now, the role of the lawyer is very different. So, and not every province and territory has children's lawyers. So there's the children's lawyer in the Northwest Territories, and they take a instructional point of view. They see children and young people as their client, and they take their instructions from their client. In British Columbia, they're trying to get some lawyers being able to represent children, but it is not, they're still working on it. In Alberta, for example, they have children's lawyers mostly in child protection, child welfare cases to represent children, and on occasion they will have a lawyer represent them in a parenting dispute. Ontario is probably the most robust government-funded program right across Ontario, where there's lawyers that represent children, both in parenting disputes as well as child welfare matters, represents children. And recently, Nova Scotia began, and I think they're still trying to, I think there's just only one lawyer who's representing children in many different proceedings. I am aware of that, but it's not as robust. There's also an interview, a judicial interview with a judge or a mediator. So some of you might have heard some of the work that I've done with judges interviewing children and doing some research about that across Canada. I'm more than happy at the end of this presentation, if anyone wants to email me and say, oh, can I have that article? I'd be more than happy to pass that on. So are we talking about choice versus voice? And we wrote a bit about this with my colleague Nick Balla, Patricia Hebert in Alberta, and myself. And while most children want to have their views considered of having to choose between their parents, because they want to have a strong relationship with both parents. But so there's a difference between wanting to have a voice but not wanting to make a choice. And that's also borne out by the research that I've also done, looking at different studies where children were interviewed under different circumstances, literally around the globe. And the consensus is that, you know, yes, they want to be heard, they just don't want to have to choose which parent. They'd rather have their parents do that, or if need be, they would prefer to have the judge do that. So what's the value of hearing from children? Well, the former Chief Justice of Canada was very clear in terms of how important it is to hear from children, and if you really want to know what they're thinking, maybe we should be asking them. And I would put it to, well, if you're going to ask them, you better provide the services is to hear from children. And if you really want to know what they're thinking, maybe we should be asking them. And I would put it to, well, if you're going to ask them, you better provide the services evenly across the country. Why should one province have more services hearing from children than other provinces, if in fact that's what we're promoting, is to hear from children? And often parents aren't really aware of their child's true feelings, and knowing them may help facilitate settlement in some of these situations. And engaging children, and we also know this from the research, does result in better outcomes in terms of relationships with both parents at the end of the day. So the Views of the Child reports, they're becoming increasingly used across Canada to get a better understanding of children's views and preferences. They are much more focused. Parents and, speaking to collateral such as yourselves who may be involved in some of these matters, teachers, doctors. And just to give you an idea, you're looking at perhaps a parenting assessment, again, depending on the province. Ontario seems to be leading the pack at, perhaps $20,000, $30,000 versus a View of the Child report that may be well under, sort of between $3,000 and $5,000, but shouldn't be more than that. But there's still some controversy and some confusion across the country because, of course, everybody likes to do it differently. Are we talking about views, or are we actually talking about what the facts of the case are. Does the reporter, typically the mental health professional, although I am aware that the lawyers do, the vast majority of them in British Columbia, do they comment on the reliability? Lawyers do, the vast majority of them in British Columbia, do they comment on the reliability of what children have to say, particularly children who have been what's affectionately referred to as an alienated child who has some very strong views about their other parent, and wanting nothing to do with them? Then how reliable is that information that the child is giving? Because perhaps they may be influenced by the parent that they're living with. So there still remains a bit of a lack of consistency in the process. So as I said, out in BC, and there are practice guidelines that are out that were produced by this group of most lawyers and some mental health professionals in British Columbia. In BC, in Manitoba, PEI, and Nova Scotia, the government also provides them. New Brunswick government pays if it is. Then you've got the Voice of the Child report with guidelines also that were developed out in Nova Scotia in 2015. And again, these are all available online for anybody who wants to take a look at them. And if you can't find them, I'd be more than happy to send them along to you. In Ontario, there was very little use before 2016. And how I sort of got involved in this is that I started to hear about it, but saw that there were no standards or guidelines, which is always a concern to me in terms of how it's being done, particularly if it's being done differently. And with this project, it was successful that it's now part of the suite of services that are actually being offered by the Children's Lawyers Office here in Ontario. So with some funding, and many thanks to some of my colleagues that were on the committee, with funding from the Law Foundation being offered by the Children's Lawyers Office here in Ontario. So with some funding, and many thanks to some of my colleagues that were on the committee, with funding from the Law Foundation, it started in about 2014. And we discussed this and had to sort out all kinds of issues because, as you can appreciate, and that's the fire alarm, I hope doesn't last too long. As you can appreciate, as an academic, I can't just all of a sudden start working with the court. So the Children's Lawyers Office was kind enough to act as the go-between. They allowed me to use their social workers. We did some training, and then we rolled this out in in several courts. One, to see differences between more urban versus rural, different kinds of populations, different issues. And as I say, there was significant administrative support from the Children's Lawyers Office. They just assigned them, they administered them, the social workers would send the reports into them, and I was always in the background waiting for everything to finish, and then I would do the research. We did the training for about 120 of them, and the reason I chose the Children's Lawyers Office is because the court was familiar with their work and accepted their work. So, and they'd already been vetted by the Children's Lawyers Office to also be qualified to be interviewing children, which was extremely important. Because if you don't know how to interview children, then this would not have gone well. So they were all paid the exact same rate. These were not all children are automatically accepted by the children's lawyer, even if they're referred to by the court to have a social worker do an assessment or have a lawyer. So these were cases that the OCL, I'll call it for short, would probably not have accepted them. And so the arrangement was that if it required more work, so if the social worker saw that there were some very serious issues going on with a child, that they would be able to be taken out of the project and go back to the office to get a more full report. And to date, there's been no social worker or mental health professional that has testified, and there's been only 3 trials. and the social worker did not testify, and those reports were accepted. So as I said, I was in the background when it was all over. I interviewed, there were about 86 children that is testified, and there's been only 3 trials, and the social worker did not testify, and those reports were accepted. So as I said, I was in the background when it was all over. I interviewed, there were about 86 children, 38 boys and 48 girls. The average age was about 12. The most common issue in dispute was the parenting arrangements, changing times, one day not working to another. But of course, there were about 11 cases where the child had not seen the parent from about 6 months to 2 years. And the court needed some information from the child's point of view. There was about 70% of the cases that settled as a direct result of these reports, and it's not just because that's what Rachel says. When I interviewed the parent or the guardian, when I interviewed the cases, 3 of the cases were automatically had to be referred to child welfare. And as I say to you, the children's law, nobody would have ever seen these children or known that there was a problem. So this almost acted as a really good first step of a triage. What's going on with these children? How much work needs to be involved to help this family? So out of that, I interviewed 34 children, 22 girls and 12 boys. I interviewed 41 parents or guardians, so some were maternal grandmothers. I interviewed 29 of the social workers. I interviewed 35 of the parents' lawyers and 28 of the judges. So this was the first piece of research that I'm aware of in North America, and I'm pretty sure anywhere else that really did kind of like a whole, looking at it from every single perspective, because what children have to say are very different than their parents, than the social worker, etc. So it was quite interesting. So I'm just going to give you a couple of the results. Again, if people want to see the full results, please feel free again to email me, and I'd be most happy to send it to you. So basically, the parents and the children and the professionals were generally satisfied. For parents, it was really quite interesting because, when you're doing a parenting assessment, you're kind of drawing, you're sort of, in many ways, judging how a parent is parenting. And this had nothing to do with any kind of judgment. This had to do with only interviewing the child on 2 occasions only, not gathering any kinds of other information, and almost verbatim reporting what does the child think to do with sort of saying negative things or looking for negative things about one parent or another. And as I said, in a few cases, it certainly did disclose some abuse. And the judges found them extremely helpful because, as many of you can appreciate across the country, legal aid is being cut significantly. Lawyers' fees are extremely high, and the majority of parents that are coming to court are without lawyers. So judges are really struggling in their court knowing what to do or how to get any information, because all they're getting are 2 parents typically saying bad things about one another and not talking much about what's going on with these children. So what are some of the lessons learned from it? Well, first of all, this is not to replace in any way, shape. Some of the lessons learned from it. Well, first of all, this is not to replace in any way, shape, or form a parenting assessment where there are more serious issues. So, for example, if there are alcohol and drug problems, where there is domestic, family violence, where children require much more in-depth assessment because they're really struggling. It doesn't replace child legal representation or mediation. It is simply another tool in the toolbox that the system can use to get information from children in a much faster, more inexpensive option. And as I say, kind of in a triage. and particularly when a lot of times children are kind of lost in the system because nobody's had a chance to see them, and it certainly provides a voice where they have had none to date. So I want to now turn a little bit and spend some time talking about the parenting provisions of the new Divorce Act. So some of you might have heard that the Federal Divorce Act is federal across every single province and territory. So this is the act that is changing. This is the act where people are married and they're separating. The province and territories have their own individual provincial, territorial, and acts apply to the unmarried and common law couples. So there's been significant changes in legislation, in the laws, particularly in Alberta, British Columbia, and Nova Scotia, that have already before plans parenting time rather than custody or access. So as of July, the term custody, I want an order for custody or I want a provision for access, they will no longer exist. The language now will be a parenting plan, which parents have to present, and they will be, one or both parents will be given parenting time. So that changes the legislation significantly. And in many provinces, they're going to have to now change their provincial legislation to make it consistent with the federal legislation. So it also means new obligations on parents and their lawyers to consider the harm that conflict is causing to their children, and to start to consider, if they hadn't before, more use of alternative dispute resolution methods, whether that's mediation, whether that's parenting coordination, and how to bring children's views before the court. It also is going to provide much more consistency for the best interest test right across the country, as well as the laws governing relocation applications are going to change quite dramatically. So as many of you know, Nova Scotia has already changed their law with respect to relocation. It's also going to improve financial disclosure, typically for child support, and will help to support these recalculation services. And also there's going to be quite an impact on the Hague Convention, which will come into force though much later. So when children are abducted, it's still not clear. So when children are abducted, it's still not clear how the language is going to, there's going to have to be some changes as well, because now you're talking about parenting, parenting time rather than custody and access that used to be part of the Hague Convention. So let's talk a little bit first about these new concepts and what does it actually mean. So there are significant decisions, and it lays out in the new Divorce Act, and they're not exhaustive, that the court has to consider in terms of their health, their education. There's now more focus on culture, language, religion, spirituality, and significant extra curricular activities. So the parenting time means that the child of the marriage spends in the care of the person, whether or not they are physically with that person during the entire time. So this is not about all of a sudden we're looking at shared parenting. This is not shared parenting. This is parenting time, and then and it works the same way. The child will live with mother from, Monday to Friday, and perhaps with father from Friday to the following Monday, etc. So it's still talking about time, not talking about shared parenting in any way. So these parenting orders will provide for, as I say, parenting time and who's going to be making the decision making. And there will be a schedule that will be in place, that you have to put in place for it. And again, the Department of Justice website, I would highly encourage you all to look, has some excellent materials that explains these new changes. So it looks at the old changes, looks at then what's been changed and what that means. So that might have an impact on some of the young people that you're involved with now. The new Divorce Act is certainly going to, as I say, encourage much more family dispute resolution, which again, this is not mandatory, but only to the, and where I say to the extent that it's appropriate, it may not be appropriate, for example, to go to mediation if there are serious issues with respect to family violence. Or where there are serious issues with respect to drug and alcohol, or where there's criminal matters that are pending. But every lawyer now has a duty to encourage the person, their client, to attempt to resolve the matters through this dispute process. Where it is appropriate, and every province has it's subject to different provincial law as to what those different processes are. So a lot of it still falls back on whether you have money to afford to have a lawyer to assist you with this. B, whether you can hire a mental health provincial law as to what those different processes are. So a lot of it still falls back on whether you have money to afford to have a lawyer to assist you with this. B, whether you can hire a mental health professional to assist you and your partner with this. Whether there are mediation services that are attached to the courts. In Ontario, we have some. In Alberta, there's also some. So every province is different, and I would encourage you then to see how it's going to impact in each province and territory. Interest test. It is not at all in any way an exhaustive list of factors. These had very few factors, which made it quite difficult. So in making the order by the court, it should include once or any other person who plays a significant role in the child's life, what the history of care is of the child, and much more focus on the child's cultural, linguistic, and spiritual upbringing and heritage, which will include Indigenous heritage. And as I say, any family violence issues the court must now consider more carefully. And that so the child's views and preferences are going to be given significant weight with respect to their age and maturity, unless they can't be ascertained if they're younger or if they have difficulty in terms of expressing themselves. As I say, it's now consistent with the Convention on the Rights of the Child, and it's like this bill is likely of the children's perspective. So there's a lot of training materials that the federal government is producing for judges, for lawyers, for parents on how to obtain children's views and encouraging these views of the child reports or judicial interviews. The caveat is that, of course, when they're thinking of changing legislation, my question to them was, well, where is the money to provide the services to each province and territory, given that they're so uneven now? And there's, and not to my surprise, there is no money as to adding additional services. So you're changing legislation, making the onus about hearing, highlighting children's views, but not providing any money to the provinces or territories, from a public standpoint to get those views across. So again, we're sort of in that limbo of those that can afford it and those that can't. Another significant, which I was very pleased to see, is the definition of family violence. So as many of you know, British Columbia probably has the one of the broadest definitions of family violence. And while people may argue, is it broad enough? It isn't broad enough. There are, cases where they've been certainly let go, where a judge may not have paid enough attention. The federal legislation for the first time is now including these issues before you. So the court has to get information or start to inquire about physical abuse, which would include forced confinement, but excluding the use of reasonable force if you're protecting themselves from another person, sexual abuse, threats to kill or cause bodily harm, harassment, which includes stalking, which also includes stalking online. That's also part of it, which is coming more and more into play. Failing to provide the necessaries of life, psychological abuse. So that's a very broad definition. Financial abuse, as you know, abuse also includes threats to kill or harm your pet, property damage, and the killing or harming of an animal and damaging property. And again, there's lots of, so it's really property. And again, there's lots of, so it's really gone to looking at family violence from control, which is the highest level of violence that's involved, where the courts and the law about whether these issues are before them in these particular families. But the application of this is very nuanced. So they have to be able to assess the nature of it, the seriousness, and the frequency. So again, the question is, many of you are asking, so that requires mental health professionals to be doing an assessment, or someone's got to get that information before the court. And you'd be absolutely correct. The judges need as much information as possible if they are to be looking at these issues. So whether there's a pattern of coercive and controlling behavior directly where the child's exposed to family violence, physical, emotional, and psychological harm or risk to the child, any compromise to the safety of the child or other family member. So you'll notice that there's a real focus on the child in relation to the family member, not just one parent or the other. And whether the family violence causes the child or other family member to fear for their own safety or for that of anyone else. And any steps taken by the person engaging in the family violence to prevent further family violence from occurring and improve their ability. So have they demonstrated to the court that they actually took perhaps some classes with respect to their impulse control? Are they following, if they were charged criminally, with their probation orders? It really took perhaps some classes with respect to their impulse control. Are they following, if they were charged criminally, with their probation orders, etc.? And then the catch-all, any other relevant factor that the court needs to consider when it comes to the best interests of children. So some of you out in British Columbia will notice that this is perhaps mirrors what some of the legislation in your province has to say about family violence. So I talked earlier about, so it's no longer the language of custody and access, but a parenting plan, which is a document that contains all the elements of what the decision-making responsibility or contact for each of the parties will have. It's encouraged with their lawyers. The parents can submit a parenting plan to the court, and if they do, the court shall include the parenting plan in the order, unless the court thinks that it's not in the child's best interest, and then the court will make amendments to that document. So many of you are saying, well, what does this document look like? And I'm giving you some resources that are very helpful. So again, myself and another colleague, we just completed for the Department of Justice a guide for making parenting plans and what it would look like. So it should be online fairly soon, where people can go into the Department of Justice website, bring up that parenting plan and actually put it in, type it in as they go and print it off, and even take that to the court as well. Right now, there's the parenting plan. I don't know if it's still online. I didn't look this morning, but the old one might still be there. Some of you might be familiar with the family wizard that often separated parents will use. They too have parenting plans, providing you're part of that organization, because there's an annual fee to use Family Wizard. And in Ontario, myself and a number of colleagues, we've created a parenting plan guide and a template. And if you go to this URL website, it takes you to the Association of Family and Conciliation Courts. Our chapters, we have one in Ontario. There's a chapter in Alberta. The parent is in the United States. And we've created our own sort of conciliation courts. Our chapters, we have one in Ontario. There's a chapter in Alberta. The parent is in the United States. And we've created our own sort of Ontario, which can also be used across Canada, of a parenting guide and template, which is actually a little bit more detailed, because when we were creating it for the federal government, we were very mindful that, you know, it had to be in a certain format. It's not as developmentally laid out as it is for Ontario, but you're more than free to look at both of them. So in the legislation, it also talks about legal advisors, and some of those don't necessarily mean that they have to be a lawyer. They can also be a paralegal. There are paralegals that I believe encourages the parents to use this resolution processes, unless it's inappropriate, as I always keep saying. That's the key. They inform the parties of family justice services. Every province and territory has government-funded family justice services, as well as the private, you pay for it. These legal advisors have to inform clients of their duties under this new act, which is to remind parents to avoid conflict, easier said than done, which I'm sure many of you are thinking. To focus on the best interests of children, which includes support for the relationship of the child with the other parent, and to obey court orders. Again, something that's easily said, not so easily done. So there's a real statutory duty on legal advisors to say to parents, you must be good parents. And it's not just an ethical duty, but it's to be able to help parents understand that this is helping children to adjust to the separation. But in the event of litigation, it also is to advance their position in court, because judges will consider this issue under the new act. These new ethical duties, I've given you a cite of John Paul Boyd. He was a lawyer in British Columbia who's now practicing law in Alberta, and that will take you to his site where he talks about the Code of Ethics. Tricia Hebert and I, we wrote a paper on the role of lawyers and what their ethical obligations are, and that's the website where you can download it and obtain it for free as well. And again, if anybody has any problems with these sites, that they are not downloading or you can't get in, please do just simply email me, and I'd be more than happy to send them your way. So as I say, the Department of Justice is in the process and has developed some really terrific materials, and particularly training materials. And if you just go to that website, every day they're updating it for information for families, for legal advisors, and service providers. The other reason they put in legal advisors is, as I said, not every like some website, every day they're updating it for information for families, for legal advisors, and service providers. The other reason they put in legal advisors is, as I said, not every like some provinces have other people who are that are allowed into court to represent families. There's also the changes are explained very clearly. So there's a document that has on the one side what the old legislation and language looks like and the change, but also it tells you the reason for the change. So it's a really handy guide. And as I say, there will be updates to the documents about making parenting plans as we completed them, and I'm pretty sure they should be going up fairly shortly if they haven't gone up already. And there will be training modules and materials that will also be available to organization across the country, so that you have information about what these changes are, what impact they may have or may not have on the work that you do for children and young people. So I want to thank you for listening. I hope it was clear. I'm going to shut down the video, the PowerPoint, and then I'm going to switch back into I'm going to stop sharing my screen, which I've now done. I'm going to go to messaging, and please feel free to write your questions. Questions go here. I'm just looking to see if there's any questions. I don't see any yet. In 15 minutes, if anybody's got any questions, please do ask. I see a number of people, users. I hope it was clear. And finally, we got a question. No questions. Thank you. Appreciated having most of the information directly on the PowerPoint. That's great. I'm pleased that the PowerPoint was clear. The information where you can go is clear, so I appreciate it. As I said, if anybody wants any of the articles or materials, I'm more than happy to send them out to you. Another person said they want the children, what the children said about, another person said they want the children, what the children said about are important for them. You're absolutely correct. Children have often, in all my research, and also I have a clinical practice where I speak with children, they've always said, you know, how come everybody listens to the adults but nobody ever listens to children? So you're absolutely correct. And it is important for them. And it helps them, you know, they are not, they did not choose this. So it becomes difficult for them to have an outlet. So I thank you for that. There was a question earlier that said, are we able to share your PowerPoint with our colleagues? Absolutely. You know, feel free to. Feel free to. Another person asked, are the courts already implementing any of the changes? Question number one, no, because the act doesn't officially pass till July 1. So everything's being put in place. There's training and discussion going across the country right now with all the judges. And then all the legal organizations are starting to get this information across to all the lawyers. How are the judges responding? I've had the privilege and honor to do some presentations in front of judges, and some seem to be responding positively. Some don't know. I mean, you don't know what it's going to look like until it actually rolls itself out. So you see the printed word, and gee, this sounds good. Children are now going to be involved. But then you find out, well, guess what? I live in Newfoundland, Labrador, in northern Labrador, and we have absolutely no services. So why does my child not have an opportunity? So there's certainly some questions around this. And then lastly, the question was what can children start being taken seriously? Absolutely. You're absolutely right. The other question was, and OCLs, which is the Office of the Children's Lawyer. Yes, they will have to be now changing and using the language of, because again, every province has to now make their family law acts compatible to the Federal Divorce Act. So assessors will have to be. Another person asked about the age. This is any age. So obviously children who are 2 or 3 years old may not be able to have their voice, but there has to be some way of getting their information before the court. These are great questions. Another one, will CAS be trained on this information? I certainly can't speak to the Children's Aid Societies in Ontario, let alone across the country. I would certainly imagine that they have to be aware of this this change in legislation, that they're going to have to be aware of. How? I don't know. It's a very good question. For those of you in all the different how, I don't know. It's a very good question. For those of you in all the different provinces, you may want to talk to someone at Children's Aid and see if they're aware of it and what they plan on doing. I'm more than sure the lawyers in the child welfare agencies are certainly aware that this legislation is coming, just as the new federal legislation in child welfare is upon them as well. Another person asked, how will the Voice of the Child report be modified or not? Right now, it is working well right across the country. Nova Scotia does it a little bit differently. Ontario does it quite similar to British Columbia, where there are 2 interviews with the child, and it's their views and preferences that are being reported. So and sometimes children don't talk about custody or access. They talk about, I want to live with this person or that person. So that language will probably continue to remain the same. I'm just going through any more questions. Can't get my thing to go down. Oh, here we go. Is mental health, another person asked, is mental health being considered in this process? I'm not sure what you mean by that question. Is that about, are you referring to the mental health of the parent, the child? Are you referring to mental health issues with respect to the Divorce Act? The abusive partners, that falls under with respect to family violence, and I laid that out in the PowerPoint. With respect to getting information from Views of the Child, that's something that the mental health professional needs to be attuned to when the child is talking about sort of what's going on in each of their homes, because again, these Views of the Child reports, whether it's in British Columbia, or well, any province or territory is not an assessment. It is simply a small picture of what's going on with the child at that particular time, and that report goes into the court. And again, in Ontario, my understanding is that now that the Children's Lawyer's Office is providing this service as part of their free services, if one of their social workers also thinks that as part of their free services, if one of their social workers also thinks that there needs to be a more expanded assessment, they will certainly do that as well. I'm just looking to see if there's any other questions. I'll just give you a couple more minutes. I mean, when I talk about the new Divorce Act, I've been aware of it and working with it in many different ways for quite a number of years, and also have been writing about it. I have a book out on parenting assessments and all the different machinations, including children who have special needs and what's required. So I've been immersed in it, and sometimes thank you very much to Allison about the work that's been done. You're absolutely right. It's long overdue. My only regret is that they did not provide additional funding and services to the provinces and territories to help deal with for a lot of these issues. That's my only regret. So perhaps with time, they will see. It's going to be a while till this really works its way through, but we'll see what happens on July, sort of the end of July into September, how it's been progressing under this new act. Sorry, that's my email. I have to keep the volume up, so I'm getting these emails. How it's been progressing under this new act. Sorry, that's my email. I have to keep the volume up, so I'm getting these emails. I'll give people a little bit more. If there really are no more questions, I'll certainly let you. I'll certainly let you all go. Again, not to belabor the point, but if anybody wants any of these articles that I've spoken about, I'd be more than happy to send them over. You can certainly find me quite easily by email. Can you provide your email address? Sure. It's RBIRN, and I'll pop up, I'm more than sure, at King's University College in London, and you can certainly email me there. Just waiting for if there's any other questions. I'm getting a few thank yous, and I appreciate your kind words. Well, I don't want to keep anybody since there's no further questions. You know how to get you know how to get a hold of me. Someone asked, can Pearl send out your PowerPoint and contact information? I believe she has. It was part of this presentation. When I talked earlier about going to the floor, the PowerPoint was attached to it. But if it isn't, she can certainly, you can and it says, actually you can download the slides in the Documents tabs, which is right on the right. So there's a messaging, there's a messaging, polls, and documents, and that's where you can download them. If you're having trouble downloading them, you can also email Pearl, and she can certainly send them to you. And she's at Reamer at boostforkids.org. Reamer is R-I-M-E-R. I think that was a question once asked before too, about sometimes people were having problems downloading those slides, or maybe just not knowing that you actually could. So as we're approaching 2 o'clock, when we have to be done, I thank you very, very much for listening. At least I know there are a few people out there, because I've had some questions, and I thank you very, very much. And I thank you also all for the great work that Boost does across this country. The more services we have, the better it is for kids. And I thank you very much for your time.